and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you the Roadside Chat. Here's a little background. All right, we're having a debate in my area about arresting an individual for a warrant or another crime, right, who has a purse or a backpack with them. Search incident to arrest. The argument is that this does not apply to their property unless the evidence could potentially be within the backpack, right? Let's say, for example, individuals on a bicycle at night, no headlight, violating a city ordinance. So far, so good. He's wearing a crossbody bag with the right on his chest. All right. His warrant is confirmed. He is handcuffed. He's advised he's under arrest. The bag is removed and placed on the hood of the vehicle. Then the person is placed in the patrol vehicle. The argument around the department is that searching the bag on scene contemporaneous with the arrest, right? Do that, or do it at the jail inside the Sally port prior to entering a secured facility. The officer mentions a case, State versus Branson, advised in 2022, advising that if the arrestee is unable to reach or control the bag, the exception to the warrantless search does not apply. The search into arrest does not apply. It states that inevitable discovery argument didn't apply in that case also because they didn't buy off on it at the suppression hearing. Guys, can you search the bag? The answer is maybe. I hate giving those answers, but we got to talk about what's going on here in the background. Arizona versus Gant is a case that came out in 2009 that has really changed the mindset on search incident to arrest. So bear with me. Let me give you a little background, right? Let's educate ourselves about what's going on. Prior to 2009, prior to Gant, there was basically this idea that cops can search a vehicle as incident to arrest. So if you arrested a person for a warrant, even though somebody else might be driving the car away, most cops in the country were still searching that car as incident to arrest because they were arrested essentially while they were driving that car. So the car was almost considered like a container. Well, Gant threw that out, right? And rightfully so. I mean, I gotta admit to you that even when I was doing these searches prior to Gant, they felt wrong, right? There's just something about it that just felt wrong. I know what you noticed. It's just that you're searching this guy's property with no justification whatsoever. The car is being driven away. He's arrested for a warrant. There's no evidence of a warrant in that car. It's right. So that's why it felt wrong. So, okay, but Gant only applied to vehicles, and here's the change of events is that courts are now applying Gant, that logic that, hey, look, why are you searching the person's property when there's no access? The guy's in the back of the police car, right? For example, here and also in Gant. And two, there's just no evidence associated with a warrant, driving without a license, no headlight on a bicycle, and so forth. Now, so that's the problem. It's not just this case, Branson, it's also several other cases out of the 10th Circuit, the 4th Circuit. Nevada Supreme Court has also essentially said the same thing. And it's just, we don't have a Supreme Court decision on whether or not this is what they would endorse. It is persuasive. Their argument is persuasive that, hey, look, if the person does not have access to the bag, why would you even, why call it search and arrest when there's no evidence? Okay, so what's the alternative? The alternative is to actually just call this a booking search exception. So you bring the bag, or you do it in the field, whatever you think is safe. If you're going to bring the bag with you to the jail, well, there's another exception to the warrant requirement, which is the booking search. It's an inventory. You don't want to bring dangerous items to the jail. Also, there's a government interest in inventorying the person's property so that they get back what they came in with. But here's the issue. The issue is going to be this. He's with a friend, and he wants to give that cross-body bag to his friend. And you have no reasonable suspicion that the guy's armed and dangerous. So take that out of there. You also have no probable cause that there's evidence. So take that out of there. All you have is a hunch that he's trying to pass off contraband to his friend. And He's like, I don't want to take this to jail. And his friend is willing to receive the property. Now, my friends, what are you going to do? What is your move? You're going to search it anyway? And if you search it anyway, what are you going to call that? Right? You're going to call it search into arrest, but yet the guy's been removed? So let me tell you what I would do. I would not search it. I would let his friend take his property, right? I think that to me is what's reasonable under the Fourth Amendment. That appears to be more reasonable than forcing a search with no justification. If you have a justification, guns, evidence, and so forth, then you got to, maybe make a different choice. But I'm just talking about this vanilla, no extra articulation besides I just want to get into it because of a hunch or whatever. I don't think that's on firm ground. So that's my opinion. This is not. This is in conflict. This is in flux. I would love the Supreme Court to get involved in this one, but my money is on if they have somebody else to take the property, that's probably what you should do. All right? I hope it helps moving the discussion along. Even if you disagree with me, put down in the comments, hey, what about this case or what about that? That's fine. We can keep the conversation going, but based on the facts that my friend gave me here, that's what I would do. All right? All right. Stay safe. See you next time. Oh, also, just real quick, do you want to write me a question? Do you want me to answer your question? Go to bluetogold.com/show and you can submit your questions there. All right?